Does Europe unofficially copy Canadian immigration law?
It sounds provocative, but consider what actually happens. Canada openly operates employer-specific work permits. Under these permits, a foreign worker may be authorized to work for a particular employer. Changing jobs can therefore also mean dealing with immigration authorities and obtaining new authorization. You may criticize this system or you may defend it, but at least the relationship is visible. The interesting question is, what happens in Europe? Because Europe looks very different on paper. We speak about temporary residence permits, humanitarian protection, subsidiary protection, tolerated residence, work authorizations, and many other legal categories. But look at the practical result for some non-EU nationals. A European citizen in Germany can normally decide, I don't like this job anymore, I found something better, I'm leaving. For certain third country nationals, that decision can become considerably more complicated. Their employment situation may be connected to their immigration status. Changing employer can therefore become not only an employment decision, but also an immigration law problem. That creates a very different relationship between employee, employer, and state. And this is where I see an interesting comparison with Canada. I am not saying that Europe secretly copied Canadian immigration legislation. Legally, these are different systems. My question is more interesting. Can two different legal systems create a similar practical dependency? And now we arrive at the bigger European problem. Since June 2026, we have seen several important developments concerning citizenship and statelessness. Sweden has tightened access to citizenship. The Netherlands has highlighted the important distinction between statelessness and simply recording somebody as having an unknown nationality. Italy has been discussing broader possibilities for citizenship revocation. And in Germany, the interesting developments are not necessarily dramatic amendments to citizenship legislation. We can also observe how administrative mechanisms can provide people with residence documentation and greater everyday stability. These measures matter, but there is a fundamental distinction that we should not forget. Giving somebody permission to remain is not the same thing as giving that person a nationality. Giving somebody permission to work is not necessarily giving that person freedom in the labor market. Giving a child another document is not necessarily solving that child's citizenship problem. Europe has become remarkably sophisticated at creating intermediate legal statuses, and perhaps that is exactly where we should become critical. Because temporary solutions are necessary when governments need time to investigate complicated cases. But what happens when temporary status lasts for years? And perhaps that is exactly where we should become critical. Because temporary solutions are necessary when governments need time to investigate complicated cases. But what happens when temporary status lasts for years? At some point, we have to ask, is temporary protection still a bridge toward a solution, or has temporary protection itself become the solution? This becomes even more serious when stateless children are involved. Governments and administrations have time. Childhood does not. A child who spends 5 or 10 years waiting for different authorities and different countries to determine responsibility will never receive those years back. And this is why I believe Europe needs to reconsider its approach. We should certainly provide temporary residence and documentation immediately when people would otherwise be left without protection. But every temporary status should contain something else. a legally identifiable exit, a route toward normal residence, a route toward unrestricted participation in society, and, where the legal conditions are fulfilled, a route toward an effective nationality. Because there is a fundamental difference between managing statelessness and ending statelessness. Europe has become quite good at the first. The challenge now is to become equally serious about the second. So I return to my original question. Does Europe unofficially copy the Canadian immigration model? Perhaps that is not even the most important question. The more important question is this: why are we still designing better ways for people to live with legal uncertainty instead of designing better ways for them to live it?